Let's first take a look at what the safety and security climate in Maharashtra looks like. Maharashtra has 165 police people for every 1 lakh population. The international minimum standard is 222. Delhi, Assam, even Jharkhand has better ratios than Maharashtra. Even here, there is a shortfall of 8,000 police personnel. On top of all this, 56% of Mumbai's police are on VIP duty when they should be protecting the public, who are also important, if we may dare to say. As the population has increased over the decades, so has the crime and the workload. Between 2002 and 2012, IPC crimes rose by 14%. At the same time, reported crimes against women rose 31%. Rapes increased by 28%. However, after the horrific gang rape in 2012, the Criminal Law Amendment Act of 2013 was passed. The law expanded the definition of rape and added other offences against women. It also made it an offence not to register complaints of sexual offence. As a result, in 1 year, there has been a 36% increase in registered cases of crimes against women and a 42% increase in registered cases of rape. Interestingly, complaints against the police have also risen. Between 2002 and 2013, there was a 47% increase in complaints against the police. According to the National Crime Records Bureau, there was officially 1 custodial death and no rapes or human rights violations by police in 2013. This is in the face of over 7,000 public complaints against the police. Also, according to the NCRB, there are no recorded disappearances of persons, no illegal detentions, no fake encounters, no extortion, no torture, no false implication, no failure in taking action, no indignity to women, no atrocities on SC/STs or other violations by the police. Each day the newspapers tell us a different story of brutality, inefficiency and public dissatisfaction. Clearly there is something very, very wrong. So the next step is to make things better, for the Maharashtra government to put in place a police that is responsive, efficient, unbiased, operationally independent and accountable. So let's see what steps the Maharashtra government has actually taken to make things better. In 2006, the Supreme Court, in what is popularly known as the Prakash Singh case, thoughtfully distilled the many recommendations of the many commissions that had looked at policing over the decades and crafted 6 clear directives that all the states and union territories of the country must adopt in order to fix India's policing problems. It was a package to be taken all together. Maharashtra submitted affidavits claiming to comply with the court's order, but this only amounted to minimal paper compliance and only for a few directives. Then in 2008, the Supreme Court set up a 3-member monitoring committee which found that Maharashtra was in actual total non-compliance with the directives. Finally, in February 2014, the government came up with an ordinance. This did not follow the Supreme Court's orders at all. The police made strong representations to the government against it, and so did aware citizens. Nothing worked. In June, in virtual secrecy, ignoring everyone's objections, the government passed the Maharashtra Police Amendment Act of 2014. It said this was done to comply with the Supreme Court's orders. Nothing could be further from the truth. We'd like to take you on a tour around the main features of the new law. The first directive requires the establishment of a State Security Commission. This is a bipartisan body intended to be a buffer between the police and the government in power. This commission filters and tempers the control that the political executive can exercise over the police. It also lays down broad policy guidelines, looks at policing plans, regularly assesses police performance, and reports all this to the Assembly. This is a very good idea to prevent illegitimate political interference over the police. However, The 2014 Act sets up a body but without any independent panel to select or remove members of the Commission, making any decision by the SSC immediately suspect. Its recommendations are also non-binding and is really only advisory in nature. The letter and spirit of the Supreme Court is immediately lost. The second directive ensures Director Generals of Police have a minimum tenure of 2 years. Through a transparent selection process, the DGP must be selected from among the 3 senior-most officers impaneled by the Union Public Service Commission. The selection is based on the candidate's length of service, service record, and range of experience. However, the Maharashtra Police Act omits the shortlisting of candidates by the UPSC, which keeps the selection of the DGP firmly in political hands without any independent shortlisting possibility. The third directive ensures 2-year tenure for operational officers all the way down to the station house officer. This was intended to reduce the use of arbitrary transfers that punish the police even when they have done nothing wrong. Yet, the Maharashtra Act allows for mid-term transfers for exceptional circumstances, for the public interest, and on account of administrative exigencies. Even though the Supreme Court's idea was to reduce discretions and arbitrary transfers, under this Act, the police can still be shunted from pillar to post. The Court's fourth directive emphasized the need to separate investigation and law and order functions of the police. Each is a specific function that requires different skills and training. In the face of this, the Maharashtra Act does not create new and specialized crime investigation units, but rests on the plea that this is somewhat already in place. The fifth directive sets up a police establishment board. This is made up of the police chief and 4 of his senior-most officers. Depending on rank, this board can decide or make recommendations to the government on transfers, postings, promotions, and other service-related matters. The directive was intended to put management where it belongs, back in the hands of the police leadership and not in the hands of any outsider. However, the Maharashtra Act deviates from the court's composition and brings in people outside the police leadership to be on this board. So, outside influences can still decide career paths and assess capabilities when this should be the job of no one else but police managers. The sixth directive requires governments to create a police complaints authority. This is a specialist body that looks into public complaints against police officers in cases of serious misconduct, including death, grievous hurt, rape, and other offences involving serious abuse of authority. The Police Complaints Authority's direct oversight is meant to give the public a local level independent go-to place for their grievances. Instead of being totally independent to the police as the Supreme Court required, the Maharashtra Act allows it to have serving police officers on it. There is no arm's length process for appointing other members, and to ensure its weakness, its recommendations are not even binding. In short, taken together, the Act completely wipes out the possibilities of good policing that the Supreme Court's directives held. In fact, it embeds into law all the bad practices that are rife and keeps the police totally in the pockets of the political executive. Throughout the years when Mumbaikars had to go through the horror of the Mumbai blasts, past 2006 when the Supreme Court passed its directives, past the monitoring committee's finding that Maharashtra had done nothing to make policing better, till now when the court is again looking to see whether its orders are being obeyed, Maharashtra has resisted improvements. In the end, the state has created a law entirely biased in favor of cementing a stranglehold grip on the police.
Good evening everybody, and I think this fantastic video from Commonwealth Human Rights Initiative really puts today's discussion in perspective. I'm sure a lot of facts that you heard today are things that you didn't even know. Most of us ask this question, why does it happen? I think you have some of the questions answered, but we're going to follow this up with a wonderful discussion on what goes wrong and where. May I welcome our three speakers onto the stage, please. Maya Darwala, Mr. Sudhakar Suradkar, and Senior Advocate Adv Desai. May I please? May I start by asking Adv Desai, convener of Police Reforms Watch, to welcome Mr. Adv Desai with the bouquet of flowers. May I request my colleague Pankaj Raheja to welcome Ms. Maya Darwala with the bouquet of flowers. Salil, may I request you to welcome Mr. Suradkar with the bouquet of flowers. On behalf of Police Reforms Watch and Moneylife Foundation, may I thank all three of you for so kindly accepting our invitation and being here today. We're really looking forward to a wonderful discussion. All of you coming here know the format. It's very, very simple. I have the honor of introducing our speakers. We have the discussion and then we have a Q&A. So I think let's quickly get down to today's proceedings. The video was unusual, that's not what we do, but I think today you are much more enlightened because you've seen it already. So, I have the pleasure of introducing, first of all, Senior Advocate Adv Desai. He's a human rights lawyer and has been practicing in the Bombay High Court and the Supreme Court, especially in matters relating to human rights, civil liberties and service law. Anyone who's an activist knows Adv Desai's wonderful work. In fact, he's been appointed amicus curiae, which is friend of the court, in so many matters relating to human rights. He addresses subjects that include illegal acts by the authorities, police brutality, as well as sexual attacks. He is a founder member of the Human Rights Law Network, which is a network of advocates working on human rights issues across the country. He's also co-convener of the Indian People's Tribunal on Environment. He's the author of a 3-volume book covering Women and Law, Law and Minority Educational Institutions in India, Health Laws and Judgments in India. So a very short introduction, but again, I feel he doesn't require to be introduced to this audience, neither do the other two panelists, the formality that I'm going through. Mr. Sudhakar Suradkar, an IPS officer retired as the Inspector General of Police. During his career spanning decades, Mr. Suradkar arrested several notorious criminals, including Bhai Thakur, a noted gangster from the Vasai-Virar belt under the Tada Act. In 1970, he arrested one person who was trying to give him a bribe of 10,000 rupees. And this case actually reached all the way to the Supreme Court, which upheld the conviction while appreciating the stand taken by Mr. Suradkar. More importantly, Mr. Suradkar is known for his frank and forthright views on police reforms and accountability. It's a subject that's very close to his heart. I now introduce Ms. Maya Darwala. She's a barrister by training. She's the director of the Commonwealth Human Rights Initiative since 1996. CHRI is an international NGO mandated to ensure practical realization of human rights across the Commonwealth. She's actively engaged in numerous human rights initiatives and concentrates on issues relating to civil liberties, including police reform, prison reform, right to information, discrimination, women's rights, freedom of expression, and human rights advocacy, as well as capacity building. She sits on the boards of several charitable institutions in India and abroad, including the International Women's Health Coalition. And before I complete the introduction to her, I think I must mention, since all of us are huge fans of her legendary father, she's the daughter of Field Marshal Sam Manekshaw. So, she doesn't like the fact that I said, introduced her saying this. And I must tell you, Maya, I did it because I couldn't bring myself to, I know that you don't like this, I couldn't bring myself to tell you I'm such a fan of your father's, but I think you should let us have this opportunity to do it. I now start the session, and I think our first speaker is going to be Mr. Adv Desai. May I invite you?
Thanks a lot. Thank you, Suchita. Thank you, Moneylife Foundation, CHRI, and the Police Reforms Watch, Dolphy, of course, for inviting me here. I've been hearing a lot about this from various people as to how enthusiastically it has been going on since last couple of months. Let me divide what I am going to say into two parts. The first part, which will be a little longer than the second one, is going to be on what we are talking about today, that is police accountability. That how do you make police accountable? How do you make police independent and police accountable both? And the second part would be the conditions under which the police are required to work, which also we must always bear in mind when we talk about police accountability, when we talk about police reforms, etc. Because the conditions under which they work is something which needs to be looked at when we criticize the police, when we call for accountability, etc. So it's something which we need to look at from both angles. Now, as we all know, police broadly perform two functions. One is the maintenance of law and order, and second is investigation of crimes. Both those aspects, that is maintenance of law and order and investigation of crimes, give tremendous powers to the police. When you talk of maintenance of law and order, you get the power of detaining people, power of arresting people who are breaking the law and order, or who are said to be breaking the law and order. When you're talking about investigation of the crime, you're talking about right from the time when a crime is reported to the police, the registration of that crime, whether it's a first information report or a non-cognizable complaint, arresting people, interrogating them, filing a charge sheet. Now, all these things give a really wide power to the police. Powers given are very, very wide. And this is where some of the problems arise. Because it is true that political independence of the police is a very important aspect of how we should go about police reforms. But there is also the other aspect, which is that even if the police is completely politically independent, it does not necessarily mean that they will not abuse the power. And that aspect also has to be considered, which is the fifth or sixth part of the film which you just saw, namely the police complaints mechanism. I would be talking about that aspect much more, because if you look at the history, all of us, even law-abiding people, when you have to go to the police station, even to lodge a complaint, we go with certain amount of trepidation, some apprehension. The ideal thing that we respect the police are our friends, etc., is one thing. But when we actually have to deal with the police, all of us have some kind of a trepidation, some kind of a fear, some kind of a apprehension that how will they treat us? Will they? And there is a history to this. This is not something which is completely a fairy tale in our minds. There is a history. We have read, we have come across cases where complaints which ought to be filed are not filed. Complaints where people are arrested sometimes on false charges. There are cases, repeated cases of brutality of the police against people. So you have of course the demand of corruption, demand of bribes, etc., and all this. All this has become such a part of our day-to-day life that these are the things you expect from the police. Police, if they arrest somebody, will beat up somebody. That's something we accept. I don't mean to say that every policeman does it, but I'm just saying that our impression, by and large, that many of them will ask for bribes to act in a particular way. Many of them will direct their energies towards a particular case and not towards another case where they are not sufficiently interested. So all these things are something which a lot of international bodies, a lot of national bodies like the National Human Rights Commission, etc., have from the beginning been talking about. In fact, if you see the Indian Evidence Act, which was brought into effect in the 1860s by the British, even they realized that police can't be trusted too much. And therefore there was a clause made, section 25, which said that any confession made to a police officer will not be admissible in evidence. And this is way back in 1860s. It's not something which today somebody feels that confession can be extracted by ABC means. Even the British realized that. Okay? And that has continued up till now, that any confession made to a police officer is not admissible in evidence. And similar provisions are there in the Indian Penal Code, section 326, 328, etc., etc., where extracting confession is made punishable, etc. So the law is very clear. The law says that you cannot torture anybody, you cannot extract third degree treatment, impose third degree treatment on anybody in order to extract confession or for any other purpose. Okay, you can't. You have to use investigative tools which are at your with you in order to find out who has committed the crime, why has the crime been committed, etc., etc. Okay. But that's law on paper. Okay. The Supreme Court has time and again said that torture is violative of fundamental rights. That's again on paper. Maharashtra leads the country in terms of custodial deaths. Okay. So you have a situation whereby police brutality is something which is a reality. Again, let me just make it clear that I am not saying that every police officer does it, but this is seen as a reality by and large. In order to counter that, as I said, a lot of cases go to court. Okay, that what do we do with police brutality? Now they say from time to time that okay, police brutality is banned, police can't use torture, etc., etc. But at the end of it, you don't find many convictions on torture. You don't find many convictions on custodial deaths. The Supreme Court developed a new remedy in respect of custodial deaths and torture and all that, which is that okay, if we find that somebody was tortured in police station, we'll provide compensation to that person. And that's a new remedy developed by the Supreme Court way back in the 80s and which has been going on. You provide compensation. Sometimes a custodial death occurs and you don't know which police officer was involved. It's a police station having 40 police officers. Who is involved? Nobody knows that. So that's the other thing which happens. That you don't know who actually is. You get a dead body outside, you don't know how that person was killed. So the Supreme Court developed this remedy of having compensation being given. So that is one remedy. But one of the major problems in prosecuting the police officers is section 197 of the Criminal Procedure Code. This section says that no public servant, it's not just against a police officer, no public servant can be prosecuted without the permission of the state government. And getting the permission of the state government becomes very difficult. Yeah. That's one thing which is very, very difficult to get state government's permission to actually prosecute policemen. Sometimes they give, it's not that they never not give, but a lot depends on police officers, on the state government not giving permission. So it becomes difficult to prosecute police officers. In fact, I have taken a number of training for, say, activists, lower middle class activists, poor activists, on police and the law, your rights on being arrested, your rights vis-a-vis police. And always one question comes, that it's all right, you are telling us about rights and all that, but when we tell the police, when we are taken to the police station and we say these are our rights, the police will slap us and say, "Mala hakabak shiku nako." This is the kind of so it's one thing knowing about rights, but it's another thing having effective remedies, whether against corruption, whether against brutality, whether against non-filing of complaints. Now, just 2 days back, the Supreme Court has ordered that all FIRs should be uploaded on the website within 24 hours, which is a very good step. That you upload all FIRs within 24 hours so that you know. Because sometimes I get cases where people come and say that हमने complaint file किया है. So I ask them, what is this complaint? Then they show me a chit which is basically a non-cognizable offence complaint. So though it may be a cognizable offence, it's registered as NC. The people don't know what is the difference between NC and FIR.
Even policemen don't know.
Okay. That I will not say. That you cover in your. Okay. So a lot of times, so it's a good thing that FIRs have to be uploaded. You will know. Similarly, the Supreme Court passed in B.K. Basu's judgment a number of rights for arrestees, that when you are arrested, what are your rights? That you have a right to be told what are your offences. Women ordinarily should not be arrested between sunset and sunrise, etc., etc. Various, and then the Criminal Procedure Code has been amended by including that. So there is a conscious effort to put in all these, precautions and protections for people who are arrested. But at the end of the day, okay, unless there is a mechanism which in some way provides people a remedy to make complaint without having to suffer the consequences of making that complaint, which is most important. Because there are cases, I have handled cases where people make a complaint, okay, against the police, and the next day some false charges are leveled against them. So you need to have a mechanism where you make complaint against the police, a genuine complaint I am talking about. But whenever there is a genuine case, you make a complaint and there is no counterblast from the police or from the authorities against you. That which is something which is very, very important, that kind of a mechanism. Now, India is a signatory to the Torture Convention. India signed that way back in the late 70s. But they have not really implemented it. The ratification is not happening. Under that, you have to pass a law which prohibits torture and which provides for the consequences of what happens if you are tortured or something like that. That legislation, a draft legislation was presented in the parliament in the 2001, but it has then lapsed. So nothing has happened. So you need rights. So my suggestion would be that when one is talking about, and there have been a number of reports. Okay? There are reports in 12 volumes, 13 volumes, etc., etc. And going back from British time onwards, there have been reports about police reform reports, police commission, conditions of police reports, etc. But these reports are not binding on anybody. Yeah. So these are reports which give recommendations, excellent recommendations, many of them excellent recommendations, but not implemented. Okay. So in that situation, okay, how do we, and therefore when we are talking about police accountability, okay, we need to have mechanisms, and that is where the Supreme Court's judgment in Prakash Singh's, especially the last part. The first parts I am sure my colleagues will speak about, but the last part, that is complaint mechanism. That a place where people can make complaints, where those complaints are looked into, where people are heard about their complaints. That an effective independent mechanism, not controlled either by the police or by the executive. Such a mechanism has to be set up, which is extremely crucial. Second thing is, it's very important that a law is passed concerning torture, which prohibits torture, and which provides for remedies in case people are tortured. Third thing is, there has to be an effective mechanism by which registration of FIR, registration of complaints is something which you can easily do. Whether those complaints are genuine or not, the police will look into it. That's a separate issue. But if you are finding problem even at the level of registration, see, also it depends, I guess, you will throw more light on it, that you see, the less the complaints in a police station, it's said that police station is controlling the crime much better in that locality, and therefore the tendency of not taking in as many complaints as come to show that, look, our area law and order is under control. Now, these kind of things need to be dealt with, and that's what I feel, that you need modification of 197, which is sanctioned only in certain cases from state government. A law concerning torture. We have filed a public interest litigation concerning custodial torture in the High Court, which I am handling, which is going on right now, where the court has ordered two, three things. One is, the court has ordered that there should be a CCTV camera in investigation rooms. Okay. The state agreed to it, that yes, we will put it. Okay. They will put, not that we will have access, not that anybody and everybody can have access to it, but in case of a complaint of being beaten up, at least the judge can have a look at it or something like that. And they said, we will have it as a pilot project, we will put up those cameras in 25 police stations, but up till now it has not happened, because they are still fighting about who should, how the tender should be worded, and how that, that kind of a thing. So that is the situation. So this is one aspect which I wanted to say, the 3-4 suggestions which I think are because for effective remedy vis-a-vis the police, I think these 3-4 things are important. Coming to my second point, which I will just very, very briefly touch upon, the conditions of work of police, because that's something which we have to also bear in mind. And many of the reports have dealt with these conditions. It's not that something which we are talking for the first time. A lot of reports, police reports, have NHRC, etc., have dealt with the conditions in which the police work. Because you have to realize that, you see, they are on duty all the time, virtually, in the sense that they can be called any time and every time for duty. So they are on duty. Their duty hours are very, very long. It's a stressful job. Okay? It's an extremely stressful job. This is the second thing which you must. Third thing is the political interference. And also sometimes the interference for the lower level policemen from the higher level policemen. Okay? These things really test them out quite a lot, in the sense that they stress them out. I am handling a case concerning a policeman who was staying in police quarters at BDD Chawls. BDD Chawls, about 2,400 policemen stay in those BDD Chawls as quarters. And the quarters are about 80 square feet to 100 square feet big. In that they have been staying. You can imagine the kind of situation if you are staying in those kind of quarters. The equipment is not very good. Scientific techniques of investigation are not being, taught. Now, in that kind of a situation, the workload is very, very high. The requirement of police would be X, the number of policemen required, while you actually have X minus Y policemen who have been recruited. So the recruitment is very less of the number of police, because your population is increasing. The policing requirements are increasing, but you don't have that. Yeah? So you have what is required to be done by 20 people will have to be done by 10 people. So the workload again is very, very this thing. It's a high tension job. There are many times when they put themselves in jeopardy in terms of their life. You heard what happened even just day before yesterday, that Ganpati, somebody was one policeman was virtually drowned in that pond or whatever, because he objected to certain things. So it's very. I know some of the police, because there was this demand from a lot of these hospitals saying that we should have police protection, because patients, if something happens to the patient's relatives, they come and attack and burn our hospitals and things like that. The policemen are saying that's all right. I mean, some of them came who were put on duty. They said, well, we don't get any kind of equipment with though danda. If a mob of 50 comes, what are we going to do? Yeah? We will be the first to be beaten up. So this is also the situation which they are facing. Okay? The stress on the job, long working hours, bad working conditions. Apart from transfers, you will be suspended at any time if some political bigwig doesn't like what you are doing. See, all these things also we need to look at when we are talking about police reforms in terms of accountability and police reforms in terms of conditions of work. Both have to go together. Because only when both go together will we really achieve something. Because just saying that police should be made accountable, etc., without talking about conditions is neither really fair nor will it be effective. I guess I'll stop here and let the other speakers continue. Thank you very much.